Members, may I call to order the 20th meeting of the Bills Committee on Private Columbaria Bill. We formed a quorum and it's also the appointed time. May I call the meeting to order. We are in the process of clause-by-clause scrutiny. We're up to Schedule 5, Part 2, Clause 15. Please turn to page C3646 of the Blue Bill. PAS, please. Thank you, Chairman. We completed Clause 14. So we will start with Clause 15. That is, the director may claim the cost arising from the disposal of ashes. Subsection 1. Under clauses now, if the operator or the mortgagee or whoever will be covered by the clauses here, and the person has to dispose of the abandoned ashes, and then under B, if these persons have failed to do as required, they are liable, or that person is liable to pay to the director all expenses that the director incurs in carrying out the prescribed ash disposal procedures. When we discussed Clause 13, we understood that the director would complete the remaining prescribed ash disposal procedures, and the person is liable to repay the cost to the director. So, the director can certify the cost concerned, and that is admissible in court. And 3, without limiting the general meaning of expenses, the expenses may include supervision and departmental charges. However, that's just one example. Other expenses can also be included. Subsection 4. If the director so believes, he may serve a copy of the certificate on each person whom he believes to be liable to pay the expenses. So the person who has not completed the prescribed procedures is liable. The operator or the landlord or the mortgagee can ask the relevant person to share part of the expenses. And 5, the certificate starting from the interest is recoverable as part of the expenses from a person who is liable for the expenses under subsection 1 at the annual rate of 10%, commencing first 1 month after the date of service of the certificate on the person. And payment of the expenses by any person is without prejudice to the person's right to recover the payment from any other person. That is, the person may recover the expenses from the buyer owner. And the expenses due from a person to director under this section are recoverable as a civil debt due to the government. That is, we may recover the expenses in court under a civil action. Subclause 8, a certificate purporting to be signed by the director is on its production admissible in any proceedings without further proof. And I said right from the beginning, there must be a certificate. For this purpose, bracket 9, in the absence of evidence to the contrary. Now, this is quite a common phrase in our law. The certificate is presumed to be proof of the signature of the director and of the amount of expenses due from a person referred to in earlier part of the clause. In suit, this can be used as evidence. Mr. Wong Ko-hing, through you, Chairman, I have 2 questions for the government. First, the director will recover expenses from a relevant person, that is under 1B. I'd like to know that would include legal expenses incidental to the recovery action. And secondly, subsection 5, the annual rate of 10%, will that be too little? Because interest rates do fluctuate. Well, if it is below 10%, of course, the government suffers no loss. But if it is above 10%, then there would be loss to the government. So you think that is not high enough? Can we say at the prevailing interest rate, at the prevailing annual interest rate, will that serve a higher deterrent effect? Ms. Wong. Thank you. We have a mechanism for working out the expenses. All expenses are reasonable and also incidental to the procedures will be covered. What about the legal costs incurred by the government in trying to recover the expenses? As I said, it is a civil debt. Now, if we win the case, then we can request the court to order costs, to award costs to the other party. And 10% is in fact quite a high level of interest rate. Of course, as the member said, there might be variations or interest hikes in the future. But I believe there is justification for the rate to be fixed at 10%. And all along, I think the operation is okay. Mr. Wong Ko-hing, 10% is of course a high compared with the current level, but there might be interest hikes in the future. So this 10% under cap 132 may be outdated already. Perhaps we can amend this to read according to the prevailing rate. What about double that of the prevailing interest rate? So if the prevailing rate is 5%, then it's 10%. So you think the 10% is not high enough to deter such behavior? Yes, 10%. If you fix it at 10%, you cannot keep abreast of the latest situation. In fact, the patrons and also the operator will share the expenses 50-50. Now, if we fix it at too high, then the costs would be then transferred to the users. Mr. James too. I think Mr. Wong Ko-hing raised an interesting point. Now, if you research into the interest rates in the past few decades, I would say that 10% is certainly a record high. And I've never seen a market interest higher than 10%. So I think 10% is safe enough. Now, assuming that there are many such cases and the prevailing interest rate is 40%, of course, you'll have to recover the expenses.
If this is the case, it must be there will be amendments. So I'm not very concerned with the 10% fixed, and I'm not concerned with any future amendments. And as for the other scenario raised by Mr. Wong, in some relevant legislations or in some legislations, similar penalties have been specified. And it's rather difficult to specify the time periods. If for floating interest rates, it's very difficult to define different situations. It's not impossible, but it would be very hard to pin it down in words. So let's just use 10% and omit words like double and, well, as far as I remember, if you want the government to come up with historical interest rates, then it's not difficult. They only have to ask for the data from the Hong Kong Monetary Authority. But I think 10% is very safe, and, well, if it's way higher than 10%, if the debts are serious, then we need a more stringent penalty or interest rate. I have a question on number 8. Section 15, section 8. Do we need the words apparent, purporting to be? Do we really need these words? It says a certificate purporting to be signed by the director under subsection 2 is on its production admissible in any proceedings without further proof. Why do we need the words purporting to be? When drafting the law, the word purported is sometimes used. So in some cases, some items are purporting to be or apparently be rather than actually be. So perhaps Phyllis can explain more. The senior assistant law draftsman. Such wording is actually very common. If we have a certificate signed by the director, if we are to prove that it's a genuine signature, then we need to go through certain legal steps to prove that it's actually signed by the director. So when we are shown a certificate, we won't have to invite the director here to prove that it's his genuine signature. And under such cases, number 8 would apply. I have a question on 15.5. I'm not sure why we need the words commencing 1 month after the day of service. for the expenses, you should have charged an annual rate of 10% starting from day one. Why would you grant a 1-month interest-free period? This is copied from CAP 132. We have to, I guess we have, this is because we have to give them a reasonable notification period. If the, well, for actual expenses, they have to pay the interest. If they, if the expense is debatable, then you have to look at the actual expenses. So you should not provide a 1-month interest-free period. Now, this is not very reasonable, and it's very hard to justify because they owe you money. PAS, well, we can look at it. I don't want to go into a debate with you, but you have to understand why this is put down. I think this is to provide a reasonable notification period. You should give them a reasonable period of time. Well, I agree with Mr. To. Well, you have notified them to pay, but if they're unwilling to pay, then that's the consequence. Well, let's, for example, if the expense is $100, if they choose to pay on the 5th day, and we have to, you have to calculate the daily interest rate. Well, then we will be dealing with very small figures, which is troublesome. I'm not sure how to simplify the scenario, but let's say if within the first 7 days there's an amount you pay, and after that you have to pay another amount, so that you won't have to calculate the very small amounts of money, and it's a waste of everyone's time. You should not give a 1-month interest-free period. This is wrong in principle. Yes, we can look at it. Section 16. Before we go to 16, we can seek civil proceedings, but then sometimes we still get bad debts, and we would impose a legal charge, just as in the buildings ordinance. If they don't pay up, we would they would not be able to transfer any properties before they pay us back. Now, Section 16. The director to provide information on ash disposal by Columbaria. This is something mentioned by Mr. Leung last time. The director may keep various records, including a list setting out 1. Each columbarium in respect of which the prescribed ash disposal procedures are being carried out. And 2. Each columbarium in respect of which the prescribed ash disposal procedures have been carried out. So in other words, if anyone wants to trace the records, we do have them. B. In respect of each columbarium referred to in paragraph A. We would have a copy of the commencement of ash disposal notice. And bracket C. In respect of each columbarium referred to in paragraph A2. According to section 11 bracket 2 of this schedule, a copy of the record of the prescribed ash disposal procedures delivered to the director must be produced. and we would keep a copy of the record. Bracket 2. On payment of the prescribed fee, the director may make them available for public inspection. A. The information kept under subsection 1, and B. To the extent to which the director has carried out the prescribed ash disposal procedures in respect of a columbarium. Under Section 65 of this ordinance, a copy of the record of the procedures kept by the director under Section 11, bracket 1 of this schedule. So we would have a copy of the procedures carried out by the director. If 70% of the work is finished and the rest is finished by completed by the director, we would have a record of such procedures. Legal advisor. Thank you, Chairman. For Section 16, the key is that the director may keep the records, but he or she does not necessarily have to do so. As explained before, the director has a discretion unless there's a reasonable excuse. So why don't you use the word must? Sometimes you use the word must. Law draftsman. Ms. Ko. We want to give a power of discretion to the director. As Ms. Wang said, director would carry out the requirements laid out in the order. As the legal advisor suggested, we would consider revising the wording. So let's give them some time to reconsider or review it. Mr. Leung Kwok-hong, in Section 16, if you say the director may keep the information or list, well, you have to make it clear under the circumstances in which the director would not have to keep the information. According to the bill, the director is not required to keep the information. I understand that you want to give him discretion, but the bill must specify the scenarios in which the director can exercise discretion. So you please point me to the right part if you can. But looking at this section cannot answer this question. If litigation is involved, the director may say that he's merely asked to keep it, but it's not compulsory. So we should deal with that. May and must are different. We will look at it. Well, in the past, some paperwork or agreements might be lost for different reasons, or I mean, some records would be might be destroyed by accident. Well, the director can offer a reasonable excuse if the information is lost due to a fire. It's a reasonable excuse. We will look into that. Next. Section 17, Annex 5 lists out the detailed procedures, and this is on alternative ash disposal procedures. Number 1, a person is treated as having carried out the prescribed ash disposal procedures in respect of a columbarium if the person has carried out in respect of the columbarium, the procedures specified in an ash disposal plan approved by the director in respect of the columbarium. So in other words, they can carry out alternative procedures, but we have a stringent gatekeeping mechanism in place.
Bracket 2. The director may, on application, approve an ash disposal plan in respect of a columbarium if it is satisfied that the procedures specified in the plans are as effective as the prescribed ash disposal procedures in facilitating the return of the ashes interred in the columbarium to an eligible claimant. That is, if there is such an application, the director may approve an alternative plan. Bracket 3. Subject to any necessary modifications, the other provisions of this ordinance apply to a person who is treated as having carried out the prescribed ash disposal procedures under subsection 1 in the same manner as they apply to a person who has carried out the prescribed ash disposal procedures. That is, if indeed the director has approved an alternative plan, or the provisions that apply to the prescribed ash disposal procedures would also apply to the alternative plan. All right, any questions? 6. Can we go back to C3514? So we've completed the. Shouldn't we go to schedule part 6? Should we go to schedule 6 or part 6? But what about part 7? So we've completed schedule 5. Let's go back to 3514, page 3514. We were up to clause 65, and then 66 was about part 2 of schedule 5. And therefore, when we reached clause 66, we went to part 2 of schedule 5. All right. Clause 66. Further provision, or rather, clause 67, discharge of obligation in respect of ashes, so that the operator, the landlord, or the mortgagee may be discharged of the obligation. Bracket 1. Subject to section 69, a person to whom an ash disposal requirement applies in respect of a columbarium is discharged from all obligations in respect of the disposal of ashes interred in the columbarium if the person complies with the requirement. That means if all the procedures are completed, then the person is discharged of his obligation. And then subsection 2, we have definitions of terms. Ash disposal requirement means A. The requirement under sections 58, 62, or 64(2) to carry out the prescribed ash disposal procedures, or B. The obligation under section 64(3). That is land or mortgage, land purchased or mortgage completed before the bill. So, under 64(3), we'll talk about an obligation to carry out either the prescribed ash disposal procedures or the on-site portion of the procedures. Of course, we want them to follow all the procedures, but if it's just for 2 months, that is also acceptable. 3. Prescribed officers or specified officers. As defined by section 65(1), who carries out the prescribed ash disposal procedures in respect of a columbarium under Section 65 is discharged from all obligations in respect of the disposal of ashes interred in the columbarium. So whether it be the operator, the landlord, the mortgagee, or public officer, once they have carried out all the procedures, then the obligation is discharged. Please, any questions? No? Clause 68. When we discussed Clause 38, we said that a certificate of columbarium use will be registered. Also, if the procedures are complete, then the land may be released, and then a certificate of cessation of columbarium use would be granted. Subsection 1. If someone applies to the licensing board, and if the board is satisfied that the prescribed ash disposal procedures or the on-site portion of the procedures have been carried out, in respect of any premises against which a certificate of columbarium use is registered, then the board may issue a certificate that the premises cease to be a columbarium. This must be registered with the lands registry for future transactions. So, subsection 2 says, an application for the purposes of subsection 1 must be made by A, the owner of the premises, or B, the holder of a specified instrument in respect of the premises, or C, a specified officer as defined by Section 65(1). Bracket 3. A person to whom a certificate is issued under subsection 1 in respect of any premises may register the certificate against the premises in the land registry. And I also like to add, this is mentioned by the legal advisors as well. We only talked about the owner of the premises here. Would that be too narrow? What about someone in possession of the premises, such as the mortgagee, or the someone who inherits the estate? Well, they can also register. It is suggested that they can, they should be allowed to register as well. So we will consider this proposal. 69. Contractual obligations not affected. All right, the ash. This is about part 7. Now, the ash disposal procedures are completed, regardless of who completes it. The consumers can still seek compensation, and their right to claim compensation will not be prejudiced, even though if the ashes are all removed, the consumers can still claim for compensation. Part 6. C3486. Yes. So we have completed the ash disposal procedures. Now, the FHD is responsible for regular enforcement, and they must be given they must be given powers to do that. 68. authorized officers. The director may appoint a public officer as an authorized officer for the purposes of this ordinance. The legal advisor asked whether there will be any written authorization that can be produced upon request. We will consider this possibility. Cap 171, Protection of Fisheries Ordinance, has got a similar provision. The authorization has to be in writing and must be produced upon a reasonable request. So it's a very simple clause. We're going to add that to the bill. If there are no questions, then clause 49, power to inspect Columbaria. Now, clause 49 is about a valid or a specified instrument. Dr. Priscilla Leung, we're at clause 49. Now, if it is an unlicensed operation of the license is still under application, then clause 49 is talking about a valid instrument. 1. For the purposes of this ordinance, director or any authorized officer has power to do all or any of the following things. 1. To enter and inspect at all reasonable times a columbarium in respect of which a specified instrument is in force. So long as there is a specified instrument in force, then the director of any authorized officer can ask to enter and inspect the premises at all reasonable times. B, to require a person taking part in the operation or management of the columbarium to 1. Produce a book, document, or any other article in the person's possession that relates to the operation or management of the columbarium or to any other activity in respect of the columbarium. Or 2. To furnish any information in the person's possession that relates to the operation, management, or activity. So the first is on books, documents, and any articles relevant, and 2, furnish any information relevant. C, to inspect, remove, and impound for the purpose of examination for so long as the director or authorized person may consider necessary, and to examine and copy any such book, document, or article. So these items may be kept for as long as considered necessary by the director or an authorized officer. What we mean by for as long as means that once that period is over, the items have to be returned. But the legal advisor has suggested that perhaps we should make this provision clearer. Well, I think is expressly provided in other provisions that such items should be returned. Yes, I think we should amend the provision to for clarity's sake. D, to conduct an examination and inquiry that may be necessary for ascertaining whether any or all of the following is being or has been complied with. 1. This ordinance. 2. The conditions of a specified instrument. Or 3. The management plan approved for the purposes of Section 13.2 to ensure compliance. E, to exercise any other powers that may be necessary for giving effect to the provisions of this ordinance. 2. A person holding a specified instrument and the employees, servants, or agents of the person must provide the assistance and information required by the director or any authorized officer for exercising the powers under this section. Any questions? Legal advisor. Thank you. Under 49(1)(b), there is the power. There is the power to exercise any powers that may be necessary for giving effect to the provisions of this ordinance. This seems rather wide. Can you give us the justifications? Well, this drafting is found in other legislation as well.
There are a lot of different clauses. Some deal with authorized or unauthorized operations, and they talk about the management of ashes. So in many cases, powers have to be exercised, and as such, we have a catch-all provision. Would the scope of power be too wide? Law draftsman? This is a common way to draft the provisions. And in the copyright ordinance, dutiable commodities ordinance, and so on, similar provisions are given. This is a catch-all provision. And this provision covers situations in which other powers have to be necessarily exercised. This would ensure the effectiveness of the ordinance. So members, please consider whether you would empower the government, the public officers with such rights. Is there any way to empower them without giving them such wide powers? If you can list out the specific powers required, then that could be better. Right now, this is a catch-all provision to cover any kinds of powers. Can you be more specific, or can you give a recommendation for the government? I feel that we have to do something about it. We have to give them extra powers, but right now the scope of power is too much. We can consult the legal advisor, but we do need some restrictions to the scope of power. After this meeting, can you discuss this with the law draftsman? Yes, it's possible. We can think about the specific powers required. In principle, we agree with this, but in terms of the wording, we cannot allow unlimited powers. Can you consider that? All right. Next, clause 50, power to enter and search, etc. Brackets 1. First of all, if a search warrant is required, and second, without a search warrant, certain things can still be done under contingency scenarios. First, if satisfied by information on oath that there are reasonable grounds for suspecting that there is in any premises anything which is or contains or which is likely to be or to contain evidence of an offense under this ordinance, a magistrate may issue a search warrant in respect of the premises. If the magistrate is satisfied by the information, a search warrant can be issued. And 2, the search warrant may authorize the director or an authorized officer to A, break into and forcibly enter the premises and search the premises, B, seize, remove, or impound anything which appears to the director or authorized officer to be or to contain, or to be likely to be, or to contain evidence of an offense under the ordinance. C. Remove by force a person or thing obstructing the director or authorized officer in the exercise of a power conferred on the director or authorized officer by this section. And D. Detain a person found in the premises until the premises have been searched. 3. In some cases, a search warrant is not necessary, but then the items under 2A to D can still be carried out. A. If there are reasonable grounds for suspecting that there is in the premises anything which is or contains or which is likely to be or to contain evidence of an offense under this ordinance, and the delay necessary to obtain a search warrant could result in the loss or destruction of evidence, or for any other reason it would not be reasonably practicable to obtain a search warrant. And such cases, the director and authorized officer may exercise any of the powers referred to in subsection 2 in respect of any premises. And brackets 4, if the director or an authorized officer seizes, removes, or impounds anything under subsection 2B, the director or authorized officer must post at a conspicuous place outside the premises a notice written in the Chinese language declaring the seizure, removal, or impoundment. And B, the notice must state that the owner of the thing may, under section 53, which we will talk about in a moment, apply to the director for the thing to be returned to the owner within the time specified in that section. Any questions, legal advisor? Brackets 4 is about the director or authorized officer. Would the items in number 3 be, bracket 3 be involved? Yes, our policy intention is to include them. Perhaps the law draftsman can explain more. ABCD lists out the things to be done, and brackets 3 lists out the situations in which the items in 2ABCD can be done without a search warrant. So the focus is on ABCD. So we should include both 2 and 3. Would you able to achieve what you intend through such wording? In the subsection 2B or 3, we would see if we need to revise bracket 3. Law draftsman? We would consider clarifying the wording. According to the existing wording, according to 50 brackets 2, well, according to section 2 and 3, we would see if this is the best way to word it. We might include clause 2. If clause 3 refers to clause 2, then we only need to mention clause 2. We will follow up on that. Any questions? Legal advisor. Number 4. We would cross out those words. We would show a notice in a conspicuous spot. Usually these notices are bilingual, so we don't have to specify the Chinese language. It does not necessarily have to be in Chinese. Now 51. Power of arrest. Brackets 1. If the director or an authorized officer reasonably suspects that a person has committed or is committing an offense under this ordinance, the director or authorized officer may arrest the person without a warrant. Brackets 2. The director or an authorized officer may use all reasonable means necessary to make the arrest if the person A forcibly resists the attempts of the director or authorized officer to arrest the person, or B attempts to evade the arrest. Brackets 3. If the director or an authorized officer arrests a person under this section, the director or authorized officer must immediately take the person to the nearest police station or hand the person over to the custody of a police officer to be dealt with in accordance with the Police Force Ordinance Cap 232. What does it mean by reasonable means? This refers to reasonable non-violent means. Why don't you follow the police's definition? The FEHD is the enforcement unit, and similar provisions are in place for other ordinances. For example, the Fisheries Protection Ordinance. If a person is arrested by the director of FEH, if you look at Cap 131, Section 7, bracket 6, then the person would be taken to the nearest police station or a police officer. We know the police is very busy, so we don't want to, increase their burden. But then the police have to exercise the powers under Cap 232 to deal with the person under custody. Any other questions? If not, move on to 52. Offense of obstruction of entry, inspection, arrests, etc. Brackets 1. A person commits an offense if the person A willfully obstructs the exercise of a power under Section 49, 50, or 51. B, without reasonable excuse, fails to produce a book, document, or article required to be produced under Section 49, brackets 1, bracket B, or furnish information required to be furnished under that section. Or C, furnishes the director or an authorized officer with information knowing that it's false or misleading in a material particular. Brackets 2. A person who commits an offense under subsection 1 is liable on conviction to a fine at level 4 and to imprisonment for 6 months. Mr. Albert Chan, I'd like to know the scope. Some premises are located on private land, some on government land. In Tuen Mun, you know that government land is out of bounds, whether it's on private or public land or government land. If you need to pass by private land to reach government land, we are allowed to enter both private or public land. So the land ownership is not relevant as long as the premises is valid and you can exercise Clause 52, right? Yes. Now move on to Clause 53. Disposal of things seized, removed, or impounded. Brackets 1. If anything seized, removed, or impounded under Section 50, brackets 2, brackets B is required or likely to be required for production in evidence in any proceedings under this ordinance, the director may retain the thing until the proceedings are abandoned or determined. And again, such provisions are very common. We would retain the relevant items for legal proceedings unless a verdict is already out. Brackets 2. Within 60 days after the proceedings are abandoned or determined, the owner of the thing seized, removed, or impounded may apply to the director for the thing to be returned to the owner. Brackets 3. if the owner of the thing has not acted as provided under subsection 2, the thing A is to become the property of the government, free from all liens, claims, or encumbrances, and B may be sold or otherwise disposed of in a manner that the director thinks fit.
Mr. Chen, what about the urns holding the ashes? Well, they will have to be dealt with in accordance with the ashes disposal procedures. Now we're talking about books, documents, and records used for court proceedings. So 53 doesn't include ashes. Yes, we have very clear ash disposal procedures. I think that this provision has to be read together with clause 49 about a seizure or requirement of book, document, or article. Legal advisor. But any other thing here may cover ash disposal, may cover ashes. Will you include, say, excluding cash ashes here? Because that's the most sensitive or controversial part. We'll think about it. Okay. Mr. Leung Kwok Hong. Well, if there are other provisions governing the disposal of ashes, I think those provisions would for sure override any requirements here. Now, if someone chooses to argue that is something for lawyers in the future, well, because there are other provisions regulating that, I'm sure those regulations or provisions will override this. But here it says that the items may retain the thing that may cover ashes, because this would be separated from ash disposal procedures. But ashes have to be dealt with in a very stringent manner, and there are provisions on that. Now, so the thing here, anything here should not cover ashes. Do you get my point? I do. I think Mr. Leung Kwok has a point, because you have stringent procedures on ashes disposal. But there is no harm in adding that. But whether it is necessary, well, the administration may reconsider. Because there may be implications on future litigations, although there are very clear provisions on ashes disposal. Now here, because it is the government who retains or sees things from private citizens, so I don't think the government will be so stupid as to do something to cause trouble for itself. If it were Mr. Leung Kwok Hong who got it, then perhaps it's different. No. You have very stringent procedures for dealing with ashes disposal. So I think usually you people may keep the ashes for litigations. Legal advisor. Here it says that if 60 days after the proceedings are abandoned or determined, the owner of the thing seized or removed or impounded may be property of the government. What's the justification? Well, I think there are similar provisions under Cap 132. Now, we must have some procedures to follow. It cannot be indefinite. So I think there are similar provisions under Cap 132. Well, if people do not come to claim such items, well, if they don't, then we can sell it or dispose of it in a manner that we think fit. Now, we can return the thing if the owner claims for it. And of course, there are two scenarios. If somebody wants to claim it, of course, you should give it back to him. And you will notify him to reclaim it, and the expiry date is 61 days. What if the person comes on day 61? Will you return the thing to him? I think the thing should be returned unless it is already disposed of. That is, if the person comes after the deadline, he may not necessarily get the thing. All right. So the point here is to ensure that the person cannot hold you liable if the thing no longer is already been disposed of. 54. Enforcement notice. We have many requirements, and there may be contravention. So we use enforcement notices to force a person concerned to rectify, so that we don't have to revoke the licenses so lightly. So 1, the director may, by notice or enforcement notice, require the holder of a specified instrument in respect of a columbarium to do one or more of the following. A. To end a contravention of a condition to which the instrument is subject. That is, we will ask the person to end a contravention. B. To remedy the consequences of the contravention, and C. To prevent the recurrence of the contravention. Bracket 2. The enforcement notice must state a few things. A. The particulars of the contravention concerned and the time within which the contravention must end. B. If applicable, the action that the recipient must take to remedy the consequences of the contravention and the time within which the action must be taken. C. Any action that the recipient must take to prevent the recurrence of the contravention and the time within which the action must be taken. D. That a failure without reasonable excuse to comply with the notice is an offense. And E. If paragraph B or C applies, 1. That if the recipient fails to take the action referred to in that paragraph within the stated time, the director may arrange for the action to be taken to remedy the consequences of the contravention or to prevent the recurrence of the contravention. And 2. That the recipient will be liable for the expenses of taking the action by the director. Mr. He, we are on page C3496. We just covered what's required in the enforcement notice. Bracket 3. The recipient of an enforcement notice who, without reasonable excuse, fails to comply with notice commits an offense and is liable on conviction to a fine at level 3. 4. Indeed, we referred to this as the recipient of an enforcement notice fails to take the action stated in the notice for remedying the consequences of a contravention or preventing the recurrence of the contravention, then the director may arrange for any action to be taken that he considers necessary or desirable to remedy the consequences or prevent the recurrence. And 5. The expenses of any action taken under subsection 4 are recoverable as a civil debt from the recipient of the enforcement notice. All right, any questions on 54? Mr. Wong Yukman. Well, under bracket 4, if the recipient of an enforcement notice fails to take the action stated in the notice for remedying the consequences of a contravention stated in the notice or preventing the recurrence of the contravention, the director may arrange for any action to be taken that the director considers necessary. The Chinese 可取 does it mean desirable or necessary? What do you mean by 可取? Because there is 採取 to take and 可取 because the Chinese term 可取 can be ambiguous. Yes, 可取 here means desirable, not action that can be taken. What's the English term? What's the English equivalent? Desirable. So that is not to take. 可取 here doesn't mean to take, but desirable. Because I see the term 採取 to take earlier in the same provision. Here it says necessary or desirable. Perhaps you should replace the term with another one to avoid confusion. Yes, any other question? Bracket 1. The enforcement notice. The recipient, meaning the person with a specified instrument, has to do one or more of the following. Is it the case that sometimes there may only be one requirement, sometimes 3 or all? Yes. You just address the chairman. Either to end the contravention or to remedy the consequences of the contravention or to prevent recurrence, or one or the other. But there must be A first before you can have B, C. There must be a contravention and then you end it before you can remedy it and then avoid doing it again. You just address the chairman. Well, perhaps you are handsome. Well, if it is already done, sometimes you can't end it, so you would ask for remedy. I still fail to get it. Perhaps, for instance, burning of chores. It is after the Qingming festival is already done. You can't ask them to end the act, given that it's already stopped, over. Will 2A certainly occur? Here it says one or more. Well, it can be A, B, or C. Only one that can be any combination. Well, if 1A is not necessarily the situation, then perhaps the same applies to 2A. You may need to say if applicable. What particulars of the contravention must be covered? When we ask for remedy or to prevent the recurrence, then we must give a date. 2A, B, C, perhaps it would be better if we add if applicable to 2A and C. Because in 2 you say the enforcement notice must state, so it's better to add if applicable. Legal advisor. Usually, the Chinese rendition for enforcement notice is 執行通知. Why is it 執法通知 here? We'll go and check. There are different renditions in different pieces of legislation. 執行通知 is more commonly seen in legislation than 執法通知. Well, I think the legal advisor's challenge is it should be 執行通知 instead of 執法通知. You have to You have to explain. I think in this case, the rendition should be 執行通知 instead of 執法通知, enforcement notice. So one by one, please. Mr. Wong Yuk-man asked whether it should be 執行通知. We'll think about it. 54, enforcement notice. I think it is something for the director to enforce. Since the director is enforcing a piece of legislation, so it should be 執法通知.
Says the director may by notice brackets enforcement notice. So in other words, it's about law enforcement or law enforcement. Is it referring to law enforcement? Let's look at the previous lines. Usually the Chinese is 執行通知 instead of 執法通知. And the power of arrest is mentioned. And it says contravention of a condition to which the instrument is subject. And it says to remedy the consequences of the contravention and to prevent the recurrence of the contravention. This is not about law enforcement. So clause 54 is about enforcement notice and what to do with the sub-items. The legal advisor just reminded us the Chinese rendition 執法通知 might be problematic and 執行通知 might be better. For 148, authorized officers and in 48, the director may appoint a public officer as an authorized officer for the purposes of this ordinance. See 3487, the part on enforcement. 1A is on is about to end the contravention of a condition to which the instrument is subject. You don't have to, law enforcement is not just about arresting people. Sometimes you would arrest people or remove things must be done by an enforcement officer. But in some cases, it's a contravention of rules or requirements instead of the law. Part 6 is on enforcement. Well, if you say that the title of Part 6, the Chinese rendition 執法 is wrong, enforcement can be rendered as 執法. Well, law enforcement must have a legal basis. For instance, if a police officer asks me to go to the police station, and if the officer says, you have to arrest me or else I won't follow you to the police station. And in this case, the law must be enforced. The speaker is not coming through. When you look at C374, 3487 or 3486, the title is enforcement. Mr. Leung, you want to retain the Chinese rendition 執法通知, right? Yes, there are two different views. This is about law enforcement. If not, let's ask the government to deal with it. We will go back and look at it. I've explained the logic already. And in 54 brackets 4, the enforcement notice must be complied with. And if an appeal is lodged under clause 72(1) brackets F, what do we do? For licenses or instruments, if an appeal is lodged, then the enforcement would be postponed. But there's no such mechanism here. Even if an appeal is lodged, the enforcement notice would still be carried out. I agree. Or else if multiple appeals are lodged, then it might be problematic. All right. Now, part 9. C3538. Miscellaneous. The licensing body is empowered certain rights under the ordinance, and Clause 81 is on delegation. The director may, in writing, delegate to a public officer any of his or her functions or powers under the ordinance other than this power of delegation. What does it actually mean? Perhaps the law draftsman can elaborate. The director can delegate his or her functions or powers under this ordinance, but the director cannot allow the public officer to further delegate his or her power. So in other words, any powers may be delegated, but according to the ordinance, the power of delegation cannot be delegated to another person. It says the director may, in writing, delegate to a public officer any of his or her functions or powers under the ordinance other than this power of delegation. This is so. Where is the subject? Where do you attach other than this power of delegation? I don't really understand. I know what you mean, but it's difficult to understand. But I think your intention is not expressed properly in this line. You said other than this power of delegation. Well, the subject is apparently the director. It's a contradiction. And it says the director can delegate any of his or her functions of powers other than this power of delegation. So what is the subject for the final clause? I think you can just omit the last part because the director is the only person who can delegate his or her powers or functions. So, but by adding this extra clause at the end, you are making things more complicated. And in the Chinese rendition, it says 但此項轉授權利除外. It doesn't align with the English version other than this power of delegation. So the meaning is that only the director can exercise this power of delegation. No one else can delegate the powers. Is that the case, PAS? Does it mean no one else can have this power of delegation? If that's the case, you have to revise it. First of all, the director cannot transfer this power of delegation to anyone else. And as such, the powers or functions cannot be redelegated. So you have to put it down clearly. You said the director may, in writing, delegate to a public officer any of his or her functions or powers. You should not use the word may. So this is the ensuing clause, other than this part of delegation, is a contradiction. So clause 81 is about the delegation of functions of powers. But then the actual power of delegation cannot be delegated. I think the law draftsman should go back and think about it clearly. I think we all agree. The power of delegation of the director cannot be further delegated. But the current wording is not clear. I am very sure about that. I don't really understand. So in other words, the power of delegation cannot be further delegated. Perhaps in the Chinese rendition, if 但此項轉授權力除外 can be better, can be more closely associated with the power functions or powers, it might be better. By any of his or her functions or powers under the ordinance, this is different from the power of delegation. Under the ordinance, any powers or functions is not equivalent to the power of delegation. Do you agree? Under this ordinance, functions or powers can be delegated in writing to a public officer. So in other words, this ordinance does not allow the director to redelegate the power of delegation. As such, we don't need this part. Your concern is that the power of delegation of the director can be redelegated, but under this ordinance, there's no provision to allow for redelegation of this power of delegation. It says functions or powers under this ordinance cannot be redelegated. It's as simple as that. But the Chinese version is not clear. So can you revise the wording? Yes, we would go back and look at it again. So in other words, the power of delegation cannot be further delegated. All right, let's move on to clause 82. As you remember, when dealing with the application, the licensing authority would see whether different requirements like fire services and so on are met. And this clause empowers us to obtain other relevant information. 82 is on consultation with other authorities and persons, brackets 1. In this section, says specified person, in other words, the licensing board or director. If for the purpose of a specified person's performance of a function under this ordinance, a Columbarium's compliance with another ordinance is relevant, and a person, other enforcement authority, is conferred with the function to enforce that other ordinance. A. The specified person, in other words, the licensing board or director, may consult the other enforcement authority and may, for this purpose, present to the other enforcement authority any statement, photographs, records, including plans and other material prepared, taken, made, or obtained under the notification scheme referred to in Section 22. B. The other enforcement authority may present information that it has in connection with the enforcement of that other ordinance to the specified person. And C. The specified person, the licensing board or director may, when performing the function under this ordinance, consider and use the information, including producing the information before the appeal board hearing an appeal under Part 8. So the information can be submitted to the appeal board. Brackets 3. A specified person may consult any other enforcement authority or any other person if the expertise of the authority or person is necessary for or relevant to the performance of function under this ordinance. Any questions?
The enforcement authority, so it's the same as the term authority. All right. So I'd like to know whether in Chinese 該當局 is the same as 該執法當局. Well, it's to make it more concise, more succinct. But you've talked about 該當局 before 執法當局. You said the authority before the enforcement authority. Yes, the enforcement authority can be the planning department, the lands department, and the buildings department. Well, in English, you use enforcement authority. So do you think that it is rather cumbersome to say 該執法當局? So you mean we should say 其他執法當局? And then 該其他當局及該當局 in various places you only use the term 當局 meaning the authority without the word 執法 meaning enforcement. Yet towards the very end you use the term 該執法當局 enforcement authority. I was worried that you were talking about different things, but it turns out that they are the same. Then please consider. Perhaps for the third reference, you can remove 執法 enforcement, or you put it right from the beginning. Okay. 83. The licensing board may issue guidelines and code of practice. We've made reference to the Telecommunications Ordinance, Cap 106. And the authority is authorized to issue guidelines and code of practice there. Here, the licensing board may issue guidelines to 1. Indicate the manner in which it proposes to perform its function under this ordinance. And B. To provide guidance on the operation of any provision of this ordinance. Bracket 2. Without limiting subsection 1, the licensing board may issue guidelines. A. Indicating the considerations it proposes to take into account in making a decision under this ordinance, and B. Providing guidance on compliance with the provision of this ordinance. 3. The guidelines are not subsidiary legislation. Okay, any questions, please? No. Next, codes of practice. That is for the industry and that is the operators to follow. 1. For providing practical guidance in respect of this ordinance or conditions imposed under it, the licensing board may issue a code of practice setting out principles, procedures, guidelines, standards, and requirements in relation to Columbaria. Bracket 2. A failure on the part of any person to observe a code of practice issued under subsection 1 does not of itself render that persons liable to criminal proceedings of any kind. However, in any civil or criminal proceedings, including proceedings for any offense under this ordinance, evidence about the failure may be relied on as tending to establish or to negative any liability that is in question in those proceedings. This provision can be found in many pieces of legislation where the authority is empowered to issue codes of practice. Bracket 3, a code of practice is not subsidiary legislation. Any problem? No. Then 85, management plan. When a person applies for a license, he is required to provide a management plan under Section 13(2). So bracket 1 here says the licensing board may require a management plan submitted for approval for the purposes of Section 13(2) in respect of a columbarium to cover matters that the licensing board specifies. 2. Without limiting subsection 2, the licensing board may require the management plan to cover in respect of the columbarium concerned: A. The holding capacity for visitors and admissions control; B. The traffic and public transport arrangement or management; C. Crowd management; D. Security management; E. Manpower deployment on peak grave sweeping days or periods and other days of periods; F. A contingency plan in the event of fire or other emergency situations; and G. Measures to ensure compliance with guidelines and codes of practice issued under Sections 83 and 84. Any questions? 86. Qualified professional. Members may recall that in the bill and also in Schedule 2, require qualified professionals such as those on building safety to give certificates of compliance. So, who are the qualified professionals? 1. The licensing board may, by notice and writing, specify either generally or in a particular case or class of cases, either or both of the following to be a qualified professional for the purposes of giving certification or doing any other thing as required by provision of this ordinance: A. An authorized person; B. A registered structural engineer. Bracket 2. The notice is not subsidiary legislation. Bracket 3. In this section, authorized person and registered structural engineer have the meanings given by Section 2(1) of the Buildings Ordinance. So we are using the definitions under that ordinance. 87. Offense of providing false or misleading information. This can be found in similar ordinances. 1. A person commits an offense if the person provides information that is false or misleading in a material particular or in connection with an application the person makes under this ordinance in respect of a columbarium. 2. A person who commits an offense under subsection 1 is liable on summary conviction to a fine at level 3 and to imprisonment for 6 months. So 任何人 and 個人 refers to the same person, right? Well, in the beginning it's about anyone, and second is the one who makes an application. What about instead of 任何人在個人 you say 任何人若根據本條例? Wouldn't that be better? Why do you need to have that term 個人, that person? Drafting officer, please. I think they have to point out the subject. The person is the subject. All right. 任何人 meaning any person. 在個人 Goyen is just the same person. Perhaps they don't want to use use passive voice. Yes, the structure is such that anyone who provides material that is false or misleading and a material particular in its application, yes, that can be considered. I think they're trying to tally with the English text because they've used a person and the person in the English text. I think it's quite rare for people to say in Chinese 任何人在該人. Because it would sound like if anyone commits an offense with the person. All right, we will consider tidying up this. 88. Liabilities of directors, partners, etc. for offenses because the applicant can be a body corporate or a natural person. I think we gave a verbal reply. We will not accept unincorporated association to be the applicant. We'll provide a written reply later. Okay, who are liable? 1A. If a body corporate commits an offense under this ordinance, and B, if it is proved that the offense has been committed with the consent or connivance or is attributable to any neglect on the part of any director, manager, secretary, or other similar officer of the body corporate, that the director, manager, secretary, or other similar officer commits the like offense. So this refers to the case of a body corporate. 2. If a partner in a partnership commits an offense under this ordinance, and B, it is proved that the offense has been committed with the consent or connivance of or is attributable to any neglect on the part of any other partner in the partnership or any other person concerned in the management of the partnership, the other partner or the other person concerned in the management of the partnership commits the like offense. 3. If the affairs of a body corporate are managed by its members, subsection 1 applies in relation to the acts and defaults of a member in connection with the member's functions of management, as if the member were a director of the body corporate. Now, if it is a natural person, then we'll talk about the liability of a natural person. Legal advisor. You will not accept a non-incorporated organization. Yes, there must be a legal entity. Only a body corporate can be the applicant, but because you see, contracts will have to be signed. If the body is not a body corporate, it may not be able to honor the undertakings. And I don't think it's so difficult for an organization to be incorporated in order to be the applicant. But there are private Columbaria run by non-body corporate, maybe by natural persons or partners and companies. Take Tonghua as an example. It's incorporated under an ordinance so that they have the ability to sign contracts and legal documents. But are there cases referred to by the legal advisor? Yes, maybe organizations just such as Zhou and Tong. Then they should form a body corporate with 100% of its villagers. Can they apply for an exemption? No, they should incorporate themselves into a company. It's not that difficult. If they have the status of a body corporate, then we can take action. 15(1)(d). Clauses 1D. Exemption for pre-bill columbarium. Now, if status is changed to a body corporate, then will it still be eligible for the exemption? Well, we will think about it, because if we open the gate to non-body corporates, we may be opening a floodgate. I'm worried that charitable organizations may not be incorporated. Now, take Dongwa as an example. Well, it established, or it has formed a company to run iBakery. Otherwise, if iBakery incurs a deficit, it may eat into the finances of Dongwa. So I think it would be better if a body corporate is set up to run the columbarium. It will be better for the applicant and relevant parties. Can you please double check? All right.
Anything else? If not, next. Time limit for prosecution. And similar provisions are in place for many other legislations or ordinances. Despite Section 26 of the Magistrates' Ordinance Cap 227, proceedings may be instituted for an offence other than an indictable offence under this ordinance within 12 months after the offence is discovered by or comes to the notice of the licensing board or director. Any questions? No. Now, Clause 90, fees, brackets 1. The fee for an item specified in column 2 of Schedule 6 is payable at the time specified in column 3 of that schedule in the amount specified in column 4 of that schedule opposite to that item. Now we have to look at Schedule 6. What's the page number? C3652. We have 4 columns. Column 1 is the item, column 2 particular, column 3 when payable, and column 4 fee. So Schedule 6 lists out the details of the fees. Brackets 2. Thank you, Chairman. Schedule 6 is currently empty. Would you move an amendment? Yes, we would move a CSA. We have been working on this ordinance for more than a year, and some figures have to be updated. We did not enter the figures because they would have been outdated anyway, so we would move a CSA in order to offer up-to-date figures. Schedule 6 has nothing. In the CSA's stage, you would see the amended version. There will be additions or deletions. So in brackets 1, you have to make it very clear, or else we would be confused. We have to deal with the CSAs later. Since the government wants to provide up-to-date data, and the columns will be filled out later. Dr. Kenneth Chen, I want to clarify a point on Schedule 6. In the second reading, you would provide the figures, and you would pass the CSA and amend the schedule. And in Clause 91, you would publish the amendments by the way of a gazette. And the 49-day process would not be required. And let's move on to Clause 91, Amendment of Schedules. The Licensing Board may, with the approval of the Secretary, by notice published in the Gazette, amend Schedule 3 or 4 or Part 2 of Schedule 5. Brackets 2. The Secretary may, by notice published in the Gazette, amend Schedule 6 or 7. Next. Regulations. Brackets 1. The Secretary may make regulations A. Providing for any matter required or permitted to be prescribed under this ordinance, or B. Providing for matters that are necessary or expedient to give effect to the provisions of this ordinance. Brackets 2. Without limiting subsection brackets 1, the Secretary may make regulations A. Providing for principles, procedures, guidelines, standards, or requirements about the operation and management of a columbarium, including additional duties required of an applicant for or holder of a specified instrument. B. Restricting any subletting or assignment of the columbarium premises or any part of it in a manner that is inconsistent with the operation of a columbarium. C. Requiring that the requirements for enforceability of an agreement for the sale of an interment right under Section 41 be met in respect of each agreement for the sale of an interment right in respect of the columbarium. D. Providing for measures relating to building safety, fire safety, other safety matters, drainage and sewage, including requiring certificates or reports by a qualified professional to be submitted to the licensing board at regular intervals. E. Providing for measures for minimizing the environmental nuisance caused to the neighborhood by the operation of a columbarium. And F. Providing for any principles, procedures, guidelines, standards, or requirements relevant to any provisions of this ordinance. Brackets 3. Regulations made under this ordinance may be of general application or make different provisions for different cases or classes of cases. B. Contain any incidental, consequential, evidential, transitional, saving, or supplementary provisions that the Secretary thinks fit. 4. Regulations under this section may provide that a contravention of a regulation is an offense and may prescribe penalties for it of a fine not exceeding level 6 and imprisonment not exceeding 2 years. Any questions? Legal advisor. All right, 93 we have looked at it, and 94. Now let's move to 95. It's about Schedule 7. The time is now 6:23. Now next we would look at Part 10. So I suggest we begin from C3556, Schedule 7, C3654. So next time we can start from C3654, Schedule 7. All right. So that's all. Any other business? The next meeting would be held at 10:45 a.m. on the 7th of December. So that's all for the meeting. Thank you very much.